We now have Wayfarer's motion for continued sealing. This is a pretty good, really good filing actually, from the amazing Alexandra Shapiro. So, dear Judge Lyman, the Wayfarer parties, we know who they all are, respectfully move to seal certain exhibits and related textual references in the summary judgment and spoliation submissions. Given the volume of material, the Wayfarer parties will provide highlighted versions of the documents at issue to the court via email. In view of the strong presumption against sealing summary judgment materials and sanctions motions, the Wayfarer parties have limited their sealing request to certain narrowly tailored categories, the bulk of which Lively and Jonesworks do not object to. Personal identifying information. All parties agree that documents should be redacted to the extent they reveal personal identifying information, including cell phone numbers, email addresses, home addresses, or financial accounts. Non-party information. The Wayfarer parties seek to redact documents to the extent they disclose the identity of non-party clients of TAG, Jen Abel, Jonesworks, or work done on those clients' behalf. So, and then they list all the exhibits. This court has already held that the specific identity of clients and prospective clients who have used public relations services is sufficiently sensitive to warrant continued sealing. The materials the Wayfarer parties seek to seal would disclose work done for non-parties that is subject to confidentiality agreements with those clients. It is highly sensitive and wholly irrelevant to anything at issue in these motions, and was included only coincidentally in documents discussing other topics. In particular, unlike the Wallace parties, there is no argument that the types of work Abel and Nathan do for other clients has any relevance here, as no one is disputing that Abel and Nathan can and do provide PR services. Jonesworks does not object to these requests and indeed seeks to seal substantially similar information concerning other Jonesworks clients. We understand that Lively may object to some of the proposed redactions because the fact that some of these clients have worked with Tag or Nathan has been publicly disclosed in the media. However, the timing and nature of that work has not. Moreover, we understand that Lively does not intend to object to any of the client-related redactions concerning the Jonesworks clients, apparently recognizing that such information is typically sealed. But the principle of client privacy does not apply only to parties Lively wishes to shield. Nathan, Abel, and Tag's clients are entitled to the same protections. That's true. In addition, the Wayfarer parties seek to redact a document to the extent that it discloses the identity of an individual who was subject to an unrelated workplace complaint at Wayfarer. So that'll be Shane Norman. We know that. Courts have generally characterized personnel files as confidential and found it appropriate to enter protective orders governing their use in litigation because of the inherent potential for harm or embarrassment if the information they contain is revealed. Disclosure of personnel files, which can include confidential information, is generally subject to a protective order. Such protections are especially appropriate here, where the individual in question has nothing to do with this litigation, much less the pending motions. This individual has not been identified by any party as a witness and has not been deposed, and the disclosure of complaints against that person could cause substantial personal and professional harm. Jonesworks does not object. We understand Lively may object. Okay. I don't understand why they're bringing Shane Norman into this. He was not sexually harassed. He did actually, just for context, he withdrew his claim for racial discrimination from against Wayfarer and Justin Baldoni. He actually represents Justin Baldoni in his own business now. They're friends, and Justin Baldoni is his client. So Finally, the Wayfarer parties seek to redact a document to the extent that it discloses the identity and contact information of non-parties who have offered unrelated hotel services to defendants. Given the public scrutiny of this case, the privacy of those irrelevant parties should be protected. Lively and Jones Works do not object to this request. Non-public medical information. In the November 26th order, the court observed that medical records and detail regarding healthcare are also typically considered sufficiently sensitive to merit sealing. The Wayfarer parties accordingly seek to redact certain parties' personal and irrelevant medical information. Lively and Jones Works do not object to this request. Non-public business and financial information. In the November 26th order, this court observed that undisclosed financial information such as compensation as well as confidential commercial information are both also proper subjects for sealing where the information has no bearing on any issue in this case and would cause substantial harm to a party or non-party's competitive business. Consistent with these principles, the Wayfarer parties seek to redact the financial details of the film's profits, the daily pay rate of an actor on set, and some aspects of Lina Friedman's retainer agreement. Each of these items could be valuable to a competitor or negotiating counterparty, and none has any bearing on anything at issue in the litigation or the pending motions. Lively and Jones Works do not object to these requests. The Wayfarer parties also seek to redact information concerning the specific financial amounts Abel's new public relations firm, non-party RWA Communications, charged Wayfarer in October 2024 for services not at issue herein, and the generic terms of TAG's statement of work. This information, too, is competitively sensitive and irrelevant to the pending motions. Jones Works does not object, however, we understand Lively may do so. The Wayfarer parties also seek to redact references to other unrelated Wayfarer projects. In addition to being competitively sensitive, such information has no relationship to the subject matter of the case whatsoever and can therefore have no bearing on the motion at hand. Lively and Jones Works do not object to this request. Wholly irrelevant personal/inflammatory information. As the court stated in the November 26th order, notwithstanding the strong presumption of public access to dispositive motions, materials that evidently have no relevance to the judicial function may be sealed. The Wayfarer parties accordingly seek to seal personal communications about a TAG employee and her family, and non-party messages that could be misinterpreted as inflammatory insofar as it plays into harmful stereotypes, as well as a log of Miss Abel's phone calls. Lively and Jones Works do not object to these requests. Finally, the Wayfarer parties propose to remove Wayfarer Exhibit 163 from the docket. This 400-plus page document includes a considerable amount of personal information and was attached to the opening motion in error. It was replaced with a corrected exhibit. Okay. So that was a strong filing, actually, and it sounds like for the most part they've got Jones Works agreement on pretty much everything. Lively on the majority of stuff, so that will all be granted where there is, sort of like a stipulation in place. There's a few things that Lively is going to object to by the sound of it, or may. They include Shane Norman's complaint against Wayfarer and some of the information about Jennifer Abel's company and TAG. So I've got Blake Lively's motion for continued sealing coming up, but we will see what Blake Lively objects to in her response, which is going to be due on the 12th.